Joseph, I've seen exclusion of warranties clauses in some contracts, and I'm curious about their purpose. Could you explain?
Certainly, Linda. Just as it may be important to include warranties in an agreement, it can also be necessary to expressly exclude them. An exclusion of warranties clause makes it clear that there are no implied conditions, statements, or warranties about the quality or nature of the goods or services provided. There are two main types of warranties: express warranties, which are explicitly stated in the contract, either orally or in writing, and implied warranties, which are automatically imposed by law.
So, it's about managing expectations?
Exactly. It's about setting clear boundaries between the parties. However, it's important to note that while you can exclude certain warranties, you generally can't exclude the implied warranties incorporated by law. These are automatically included in every contract as a matter of law, and you can't simply decide to exclude them because you don't like them. Courts often require very specific language to effectively exclude warranties. The language must be clear and unambiguous. Sometimes, specific phrases like, as is, or, with all faults, are used, especially in the sale of used goods.
Can you give an example of an implied warranty that can't be excluded?
Sure. One common example is the implied warranty of merchantability. This means that the goods sold must meet certain minimum standards of quality. Another is the implied warranty of fitness for a particular purpose. This applies when the buyer relies on the seller's expertise to select a suitable product.
That makes sense. How do you go about excluding other warranties?
Good question. When excluding warranties that are not legally mandatory, you need to be very clear in your contract. The clause should explicitly state that there are no implied conditions, statements, or warranties about the quality or nature of the goods or services supplied. It should also state that the party excluding the warranty will not be liable for any claims related to warranties that haven't been expressly provided. Exclusion clauses are commonly used in several industries. For example, when selling used goods, a seller might want to exclude all warranties to limit their liability. They're also frequently found in software licenses. In these cases, the licensor might exclude warranties regarding the software's performance or suitability for a particular purpose. Similarly, a service-based business might exclude warranties to clearly define the scope and limitations of the services provided.
What might be a sample wording for such a clause?
A typical exclusion of warranties clause might read, except as expressly set forth in this agreement, the seller makes no representations or warranties, express or implied, including but not limited to the implied warranties of merchantability and fitness for a particular purpose. The seller shall not be liable for any special, indirect, incidental, or consequential damages, including but not limited to lost profits, loss of use, or business interruption, arising out of the use or inability to use the goods or services.
Are there any legal nuances to consider?
Definitely. While excluding certain warranties, it's crucial to ensure that your contract complies with the relevant laws and regulations. In some jurisdictions, consumer protection laws might impose certain warranties that cannot be waived. Always consult with a legal expert to ensure that your exclusion of warranties clause is both enforceable and compliant with applicable laws. Even if a clause is technically compliant, a court might still refuse to enforce it if it's considered unconscionable. That means it's so one-sided or unfair that enforcing it would violate basic principles of fairness.
What could happen if the clause is not properly drafted?
That's an important point. If the clause is unclear or poorly drafted, it might not be enforceable. This could leave you exposed to claims for warranties you thought you had excluded. For example, in a case involving the sale of consumer electronics, a poorly drafted exclusion clause failed to protect the seller. The language was too vague, simply stating, "no warranties," without specifying what was excluded. This resulted in a costly legal dispute for the seller. It's always best to have a legal professional review your contracts to avoid these kinds of issues.
How do companies balance the need to exclude warranties with providing some assurance to customers?
Great question. It's a balancing act. Companies need to clearly communicate the limitations of their warranties while still offering enough assurance to maintain customer trust. This often involves outlining exactly what is and isn't covered and ensuring that any exclusions are reasonable, not overly broad. For instance, A company might offer a limited warranty for a shorter duration but provide robust customer service to ensure satisfaction. One example: a home appliance company successfully balanced exclusion clauses with customer satisfaction by offering a 1-year limited warranty, supported by a dedicated service team and a satisfaction guarantee. This approach built strong trust and loyalty among customers.
Thanks, Joseph. This has been really informative. It's good to understand how these clauses work and how to use them effectively.
You're welcome, Linda. Exclusion of warranties clauses are powerful tools for managing risk. But they must be carefully drafted and reviewed to protect your interests while remaining compliant with the law.